Good morning, batch. Settle down immediately, please. Pens out, notebooks open. Welcome to today's explainer session. Now, we are covering a guaranteed, absolutely high-scoring question for your upcoming KSLU examinations, the doctrine of ostensible ownership. Let me tell you, this is an area where evaluators are notoriously unforgiving. But if you structure your answer exactly as I instruct today, you're going to secure maximum marks. So, pay strict attention.
1. Introduction. 2. Essential elements. 3. Conditions for transferee protection. 4. Landmark case laws breakdown. 5. Distinction from benami. And 6. Conclusion. Listen to me. This is your mandatory answer synopsis. Replicate this precisely on page 1 of your answer booklets before you write a single other thing. A KSLU evaluator wants to see structure before substance. Always. Let's get straight into it.
Heading 1. Introduction to Ostensible Ownership. Now I'm instructing you right now to leave a proper, clean margin on your exam sheet for this opening segment. We need to define the core purpose of this doctrine right away.
41. Section 41. I literally cannot emphasize this heavily enough. Citing Section 41 of the Transfer of Property Act 1882 is absolutely non-negotiable. If you fail to write Section 41, your marks will be instantly deducted. 0. The core concept here protects bona fide purchasers who rely on appearances. You see, in the commercial world, what you see is often what you absolutely must trust. The entire foundation of your answer rests on this specific provision stepping in to protect innocent bona fide buyers.
Ostensible owner, a person who is not the real owner but appears to be the owner with the consent, express or implied, of the real owner. Take that definition down precisely. Let's deliberately dissect this, shall we? The absolutely vital difference between a real owner and an ostensible one is that the latter only holds the express or implied consent of the true owner to project an appearance of ownership to the outside world. They hold the facade badge, not the true title.
Heading number 2. Essential elements and Section 41. Now, do not write in long, rambling paragraphs for this section. The KSLU evaluator wants crisp bullet points. Burn this exact sequence into your memory.
Point 1. He is not the real owner. Point 2. He has possession or indicia of ownership. Point 3. Such appearance is with consent of real owner. Write those down. Now, indicia of ownership simply means he holds the title deeds or maybe the keys, giving the absolute illusion of authority. And remember, these 3 strict elements are exactly what trigger the rule under Section 41. Without even one of these, especially the consent of the true owner, that person is merely a trespasser or a fraud. They are not an ostensible owner recognized by law.
Heading 3. Conditions for transferee protection. Batch, wake up. This is the functional core of your exam answer. This section details exactly when the true owner cannot avoid the transfer made by our ostensible owner.
1. Transfer is for consideration, meaning sale or value. 2. Transferee acts in good faith. 3. Reasonable care taken, meaning verify title. 4. Consent of real owner. Read these carefully and take them down. Number 1 means it must be a sale or transfer for actual value, not just a mere gift. Number 2 means an honest intention, completely without fraud. Number 3, reasonable care, means the transferee absolutely must verify the title with due diligence. And 4, the true owner must have actually allowed this whole ostensible setup. I am instructing you right now to underline keywords like consideration, good faith, and reasonable care on your exam paper. Doing that will immediately capture the KSLU evaluator's attention.
Effect: real owner cannot recover property. Transferee gets good title. So what is the exact legal effect when those 4 conditions are strictly satisfied? It's simple. The real owner cannot recover the property, and the transferee gets good title. Put simply, if the transferee checks all 4 of those boxes, the transfer becomes completely valid and binding under the law. The real owner is legally estopped, meaning they are blocked by law from ever claiming their property back.
Step 1. A allows B to appear as owner. Step 2. B sells land to C. Step 3. C verifies title and acts honestly, therefore protected. Step 4. If C fails to verify, no protection. Let's walk through this practical illustration step by step. Person A allows B to appear as the owner of the land. B then turns around and sells the land to C. Now, note step 3 very carefully. C verifies the title and acts honestly. Because of this extreme diligence, C is protected. But I am warning you, mark step 4 down carefully. If C fails to verify ownership, there is absolutely no protection. Failing that crucial verification step immediately, and I mean immediately, strips away the legal protection of Section 41.
Heading 4. Landmark Case Laws Breakdown. You cannot just state the law in law school, you must prove it. Change your pen to black or blue right now. This deep case law breakdown is your golden ticket for securing full marks on a 16-mark answer.
Ramakumar Kundu v. John McQueen. Instructing you right now, write this exact case name in a separate boxed format right in the dead center of your answer script. Make it physically impossible for the examiner to miss it.
Ratio. Established principle of protection to bona fide purchaser. Relevance. The foundational precedent for Section 41 bona fide protections. Let's break this down thoroughly. The brief background here revolves around property held by an apparent owner, where an innocent third party steps in to purchase it for value, not knowing the true background. The Privy Council's final ratio decidendi here laid down a clear marker. If a person purchases property carefully and honestly from an apparent owner, the true owner cannot later emerge from the shadows to defeat that purchase. This established principle forms the absolute bedrock relevance for everything, literally everything we study under Section 41 today. You must cite this.
Jugraj Singh v. Jaswant Singh. Command your attention here, batch. Draw a strict box around this second landmark case name as well, ensuring it stands out cleanly on the page, just like the previous one. Ratio. Emphasized requirement of reasonable care and good faith. Relevance. Strict judicial application of transferee verification duties. I will elaborate fully. The facts of this case centered specifically on the actions, or rather the inactions, of the buyer. The court's verdict strictly emphasized the absolute necessity of reasonable care and good faith by the purchaser. The absolute relevance of this case is that it shows the courts will not, under any circumstances, protect a lazy buyer. If the buyer fails their verification duties, Section 41 will not save them. Underline this case name to immediately capture the evaluator's attention for a 10-mark or 16-mark answer. It shows you know the practical limits of the law.
Heading 5. Benami transactions and conclusion. Now, I explicitly note here that this distinction frequently appears as a standalone 5-mark short note in your exam papers. You absolutely must know how to separate them clearly.
Ostensible owner operates with the consent of the real owner. Versus Benami transactions, the real owner is completely hidden, a different concept entirely. Dissect this comparison verbatim on your page. You must strictly separate the known consent mechanism we see in Section 41 from the intentionally hidden, secretive nature of Benami holdings. If an examiner asks for a distinction, this is the exact legal threshold you must explain. One relies on a permitted facade, the other relies on total concealment.
The doctrine of ostensible ownership balances true ownership with commercial fairness by protecting innocent purchasers who act in good faith and with due diligence. I strongly advise you to memorize and reproduce these exact words to close your essay perfectly. Ending on this note demonstrates immense academic maturity to the evaluator.
Consider this. If a purchaser pays full consideration and acts with honest intention, but completely fails to verify the ownership title, will Section 41 protect them? Before I dismiss the batch today, I want to conclude by challenging you with this strict exam application question. Think about the unforgiving nature of legal due diligence we just discussed in the case of Jugraj Singh. I am forcing you to ponder this before your finals. Study your notes, remember the strict structures we outlined, and I will see you in the next explainer session. Class dismissed.